but the sun's gone behind a cloud just as we start. Let's hope the meeting is cloudy. Right. Sorry about that, folks. Nothing wrong with a bit of levity once in a while. Okay. David, do we have any apologies for us?
Apologies from Councillor Powell on this morning.
Thank you very much. Councillor Powell should have been joining us today for her first Cabinet meeting, and in her absence, I would still like to welcome her to Cabinet. I'm sure she's going to be a superb addition. And as I said at the council meeting when I announced that Councillor Powell was joining us, we have a significantly increased workload because of devolution and local government reform, and Councillor Powell is going to take some of the pressure off some of us to focus those pressing matters. She's getting quite excited about joining us. I did have a long chat with her yesterday, so I think that's all going to be really good news. I have no announcements. For you, Chief Executive.
Okay.
Thank you. Any declarations of interest from anyone? No? Move on. Can we look to the minutes of the meeting held on the 11th of March? Can we confirm these, please, as an accurate record? Proposed, seconded, all in favour?
It's unanimous. Thank you, Chair.
Thank you very much indeed, everybody. So moving on then. I've not heard of any items raised by scrutiny. Have you, David?
Likewise, Chair.
Thank you. So next item is item 6, the electric vehicle infrastructure strategy. Could we have a brief introduction, please, from Councillor Wise? Sorry, before we do, we need to propose and second it. Can I have a proposer for this? Thank you, Councillor Wise. I've seen you as a proposer and I've seen Councillor Ellison as a seconder. As it's been proposed and seconded, Councillor Wise, could you introduce it, please?
This policy is required in order for us to participate in the main local electrical vehicle infrastructure project, which I'm just going to call the Levy project from now on, or I'm going to run out of spit. That aside, it provides a useful marker of our current thinking and planning, albeit it will need constant updating. Government policy, for example, was altered yesterday again, and will undoubtedly be changing again very soon. As a local authority, we want to maximise our usage of grants, government or otherwise, to expand the charging infrastructure to support current and future need. Left to the market alone, there would be very limited development in rural areas. There just aren't enough of us to make it worth their while. So it is important that we use these government funds to get the charging mechanism in place. The market in electrical vehicles has fluctuated, but current policy, even despite yesterday's announcement, is still toward expansion. And the most often voiced concern about why people aren't buying electrical vehicles is lack of infrastructure. This isn't just for our own residents who wanting to buy them, but for example, if they had someone coming to visit, they may need to charge. So this policy provides the structure around which we can develop and support future bids. Thank you.
Thank you. Any questions or comments from anyone else? Councillor Smith.
Do we know whether the grant will cover the full implementation of putting these structures in, the infrastructure in place? Will it?
We surveyed residents to find out where people would like the points put. We actually had more on the list than we had funding for the pilot. We still have more on the list than will be funded by the main. So we need to just keep applying for the next round of grants when they come round to work our way through the list.
Anything else from anyone? Okay. Well, if it's been proposed and seconded, if there are no further comments, all those in favour? Oh, I haven't said what it is. Sorry. Let me try again. Apologies, everybody. What we're voting on are the recommendations in 1.2. 1.2.1 to approve the EVI strategy for the LEVI project, which is attached at Appendix A to the report, and 1.2.2 to delegate authority to the Strategic Director for Places in consultation with the portfolio holder with responsibility for transport, environment and communities to review and update the EVI strategy as and when required. All those in favour?
That's unanimous, Chair.
Thank you very much. Moving on to Greetham's neighbourhood plan. No, we're not. I've missed one out. Thank you. Development of a refreshed Rutland local transport plan, which again is Councillor Wise. We need a proposer and a seconder in order to open the debate. So proposer, Councillor Wise, thank you. Seconder, Councillor Brown, I saw first this time, thank you. So Councillor Wise, if you'd like to introduce it, please.
Yes, thank you, Chair. In theory, a local transport plan dated 2019 to 2036 should not need a refresh. But so much has changed both nationally and regionally. Our local transport plan needs to reflect these changes. Importantly, if it does not, we may find ourselves ineligible for government funding. So we do urgently need this refresh. In addition, we've progressed through the 5-year implementation plan and have completed much of it. And I think before we continue, we ought to celebrate that fact. There aren't often we set 5-year implementation plans and actually achieve it. So I'd like to celebrate that fact, but then set the service the task of putting together another implementation plan to continue us on 2026 to 2031. And that will reflect the changes made in the local transport plan and changes in policies and actions that sit under that. The bus service improvement plan, the new digital direct rural transport, the local cycling and walking infrastructure plan. It's important this plan reflects the priorities and needs of our local community within the parameters we have to meet. For this reason, there are several points in this process where stakeholders and residents will be consulted, Cabinet permitting. That's part of why this is here today, to get permission for that. We must ensure that we are best placed to draw in grants and funding and therefore refresh our local transport plan and its implementation plan. Thank you, Chair.
Thank you. Anybody else got anything to say? If none of Cabinet has, then I have. Councillor Wise made it clear that it does seem counterintuitive to be refreshing a plan that is extant and will be until 2036. But the world is moving on apace. The various grants that we're currently eligible for, we weren't when we were preparing this plan prior to 2019 simply because they didn't exist. So new governments come up with new grants and they require us to have evidence to support any application that we might make, and that's what these plans are. This plan and other plans are the evidence that we put forward. We're demonstrating that we thought about the issue, and here's an opportunity, and we can utilise that opportunity for something we've already identified. So it's really important that they're up to date. We're in a very moving scenario with transportation, though, apart from the obvious, and one of which we've just dealt with, electric vehicle charging points. You know, we weren't really thinking much about that back in 2017 when we started working on the current plan. But more importantly, with this government's push for mayoral combined authorities, strategic authorities, transportation is one of the areas that the mayor will have as his or her responsibility. And I think it's important for us, as we're going to be only part of one, to be very clear about what our requirements and, dare I say, expectations are going forward, hence the need to refresh the current plan. And I think refresh is the right word and the right emphasis as well, because if we were to rewrite, we'd throw everything out and start again. I don't think that's necessary. And it's also time consuming and not efficient. And by refreshing what is there, we are producing what's needed, I hope, in the most efficient way possible. And I think that's extremely important as well. And I would echo the portfolio holder's comments of congratulations to staff on delivering on the first 5-year implementation plan. I think that's absolutely excellent. And clearly, the implementation plan for the next 5 years is going to be the key element in this document, both to achieve what we want, but also to put in place the building blocks for the following 5 years. So that's all I wanted to say on it. Actually, that's quite a lot. So having said all of that, it's been proposed and seconded. The recommendations are to seek formal approval to refresh Moving Rutland Forward, Rutland's 4th Local Transport Plan 2019 to 2036, to seek formal approval for the development of a new Local Transport Plan Implementation Plan 2, to delegate authority to the Strategic Director Places in consultation with the portfolio holder for Transport, Environment and Communities to refresh the Local Transport Plan 4 and develop a new Local Transport Plan Implementation Plan, including further engagement with members and stakeholders. And 1.2.3, to delegate authority to the Strategic Director Places in consultation with the portfolio holder for Transport, Environment and Communities to undertake the public consultation on the refreshed Local Transport Plan and the new implementation plan. All those in favour, please.
That's unanimous, Chair.
Thank you very much. Now we'll move on to Greetham Neighbourhood Plan. Terribly keen that the parish of Greetham gets what it wants. I was rushing ahead of myself there. This paper will be introduced by the portfolio holder for planning, that's Councillor Paul Brown. But before he does that, can I have a proposer? Thank you, Councillor Brown, and a seconder. I saw Councillor Smith, thank you. So now it's proposed and seconded. We can debate it. Councillor Brown, could you do the introduction, please?
Thank you, Chair. Neighbourhood plans are an important part of the development planning system, which was introduced by the Localism Act of 2011. Once approved, they are used to make decisions on planning applications in the areas covered by them. The Greetham Neighbourhood Plan was adopted in October 2017. And the parish council have reviewed the same and have decided to apply for minor amendments, but ones that broaden their scope of providing facilities and benefits for their community. These are contained in paragraph 231. It explains that the parish council wish to extend specific lists of projects that could potentially benefit the parish, the funding of which would come from the allocation of SIL receipts. It states that the list should now include street furniture, including grit bins, benches, and anything that is of benefit to the residents of the community. Planting of indigenous hedges, trees, shrubs, hedges, yet again, and other wildlife projects, community buildings, their improvement, and non-routine maintenance. At 233, we are advised that these amendments, being both minor and non-material to the existing neighbourhood plan, can be achieved directly by Cabinet decision and without the need for further consultation. The wording, we are informed, is in compliance with the SIL regulations. We are further advised that such general amendments are in accordance with the government guidance. I don't think there's anything much more to be said, other than it is hoped that in the future that this broader concept of what constitutes benefits to the community is then adopted in further neighbourhood proposals to avoid them having to be amended again. So I beg to move.
Thank you. Anybody else? No? I would like to say that I commend Greetham Parish Council for their keeping their neighbourhood plan under review and thinking about the things that are going to benefit their community. I mean, that is exactly what parish councils should be doing, but I'm not always convinced that it's what all parish councils do. So well done, Greetham. Councillor Smith.
I just wanted to add that as I saw through a neighbourhood plan for a parish of North Luffenham, and I would encourage any other parishes to implement a neighbourhood plan. It's a lot of work, but in the end, it produces a lot of benefits for the parish concerned. So I just encourage any people who are listening to encourage their parish council to implement one. Thank you, Jeff.
Thank you, Councillor Smith. I would endorse that, and I'm sure the rest of Cabinet would as well. I can see nods around the table. Anybody else want to say anything else on this item? In which case, it's been proposed and seconded that Cabinet approve a minor non-material amendment to the Maid Greetham Neighbourhood Plan as set out in paragraph 2.3.1 of this report, delegates authority to the Strategic Director for Places to make minor non-material modifications to any made neighbourhood plan or order where such changes would not materially affect the policies in the plan or permission granted by the order, subject to the consent of the qualifying body or bodies where they still exist. All those in favour?
Unanimous, Chair.
Thank you very much, everybody. We're now moving on to planning enforcement policy, and again that's the portfolio holder for planning, Councillor Brown. The recommendation is brief in this occasion, but nevertheless we still need it proposed and seconded before we can debate. So I see Councillor Brown proposing and Councillor Ellison seconding, in which case Councillor Brown, please.
Again, thank you, Chair. I'd firstly like to start off with thanking Justin Johnson for the amount of consultation we've had between each other to achieve what is now before us. And I think it's an excellent new policy. One of the current problems for our residents, which I suspect we've all noted from our postbank, is the question as to enforcement of conditions of those planning permissions. It is clear that there is a general perception that every single condition or aspect of planning decision has to be 100% adhered to. Where, say, a matter of permission may have been contentious in the first place, yet granted, then experience shows that the dissenters tend to then monitor all aspects of subsequent development and are very keen to report potential breaches and demand enforcement, no matter how minor the aberration may be. The law, however, is quite clear. Enforcement is a discretionary power exercisable by the planning authority. If the relevant officer decides that is the appropriate remedy. Therefore, when a suspected breach is brought to the LPA's attention, each case will be assessed on its merits. This goes for both whether the LPA decides to look into the matter or not. Also, the priority that is given to it and the remedy option that the offer decides to employ, if indeed enforcement process is decided upon. It should be noted that there are strict time bars to enforcement. This is now in nearly every case within 10 years of the putative breach. The law has changed recently to impose some of these time limits, and this is also a reason why this policy now is needed. The main purpose of this policy is therefore to provide a service that makes it clear to the public what happens when a report is made of an authorised development, what the law is, as to the requirements of our officers, how this is positively approached, and what are the criteria for dealing with any such report. Paragraph 4 gives the format of the report that we propose to use and the preferred means of it being remitted. Part 5 is novel. It provides for each inquiry to be acknowledged in not more than 3 working days. It allocates a unique reference number to aid communications and entry into an electronic case management system. Table 2 details a time frame for dealing with the report, which will depend on the seriousness of the alleged unauthorised event, and the party reporting the breach will be provided with that information in the initial acknowledgement sent to them. Table 2 also contains examples, which in part have evolved following consultation, and it is, in my opinion, those examples give a clear indication to our residents of the time allocated to their report. Our officers indicate that they regard this time frame as the maximum times and will prioritise visits based on potential harm basis. But in any event, they will strive to attend as soon as possible. Part 6 details how the appropriate action is determined. It could well be that the investigations show that there has been no breach at all. But where there is a breach, then enforcement action is initially approached on a remedial basis rather than punitive. Government requires LPAs should act proportionally. The main concern is whether any breach, if left unaddressed, would there be harm to the public amenity and indeed enough harm to warrant protection. Consequently, not all breaches will be acted upon. Should the breach be trivial or technical, causing no material harm or adverse effect on the locale, or the development in its planning merits could be regularised, then that would be the preferred method of dealing with it. In order to assess harm, there is incorporated an explanatory table 3, which contains a list of 15 effects and circumstances, each of which is allocated an appropriate weighting. Should the cumulative total weighting score 4 or less, then this would likely be granted unconditional planning permission. Then this case will be closed and advisory letters to that effect sent out, but nevertheless advising that the breach is regularised through a retrospective planning application. Should the breach score 5 or more, or would unlikely be granted unconditional planning permission, then the case will be pursued until resolved either through negotiation or formal enforcement actions. This provides our residents with an open and transparent procedure of assessing harm and for our officers an objective set of criteria for quick and effective processing of cases. The policy then goes on to detail the powers our officers have in pursuit of their duties and the full ambit of the different forms of notices that are available for enforcement, which are variable and depending on both the circumstances, the property if relevant, and the nature of the breach. It also separately deals with the powers over specific trees and untidy properties. This new policy, I believe, encapsulates a much needed comprehensive set of criteria, which is hoped will go a long way to helping residents understand both the how and the why action is or is not taken, whilst at the same time gives our officials a strong framework within which to work. It makes the procedures more transparent and therefore hopefully will manage residents' expectations, which in turn should make our service more efficient. I recommend this policy.
Thank you very much. Anybody else want to speak to it? Councillor Wise.
Can I just say one of the things I really like about this policy is how easy it is to understand. I'm not a planning wizzo, but I think I could have worked my way through this and made sense of it, and I think that is an incredible achievement given how complex this issue is.
Thank you. Councillor Smith.
Well, the three of us here sit on the planning committee. Will this be given specifically to the planning committee to let them know about the enforcement policy?
Yeah, I'll speak to the governance team and we can get it circulated, I think, to all members because it's relevant to everyone, not just those on committee.
Thank you, Mr. Johnson. I think your comments are absolutely correct. It does need to go to all members if it is approved by us this morning, and equally needs to be specifically included in the training for planning committee members. Councillor Johnson.
Thank you, Chair. I just wanted to say that I think this is an excellent exercise in transparency, which is really important in an area that can get very emotional and is personally important to many people, and where policy is often misunderstood or unknown. The second thing I was going to say was I think it's important to emphasise that we're actually in the vanguard of councils doing this sort of thing, having this sort of a policy, in the sense that it is very clear and it sets expectations that residents can have and expectations of what actions might be carried out as a result. And there are not many other councils operating such a transparent and potentially effective policy, which I think is an excellent thing.
Thank you. Anyone else? I would like to echo Councillor Johnson's comments there. We frequently, as councillors, get communication from members of the public saying, oh, this planning approval, they haven't followed it by doing X, you've got to tell them to pull it down, and this sort of thing. And actually having this policy is going to be very helpful because we'll be able to point residents to it and explain that breaches don't mean it's loss of approval, which is what people seem to think a minor breach is, even a minor breach is. I'd also like to thank both the officers and Councillor Brown for the great deal of hard work that went into this. And then a lot of extra hard work that went into it after the Cabinet saw it as well, and we pulled it apart. So thank you for your work, and I think what we've got before us today is an extremely good report and policy document. So, all those in, oh no, I haven't read out the recommendation. The recommendation is the Cabinet approves the adoption of the updated planning enforcement policy. All those in favour?
That's unanimous, Chair.
Thank you very much. Moving on, we have the Rutland Local Plan update. It's clearly Councillor Brown's morning this morning, because this is also Councillor Brown. But before we can move to debate, as always, could we have a proposer, please? Thank you, Councillor Brown. Second, thank you, Councillor Ellison. Councillor Brown.
Yes, you'll be fed up with me soon. Okay, thank you, Chair. This report is basically in three parts. Firstly, is to update you on the emerging local plan. Secondly, to approve the format of the local development scheme for 2025 to 2028, which is on Appendix 1. And thirdly, to approve the Memorandum of Understanding regarding the development of the Woolfox site. Dealing with these matters in order. Firstly, in respect of our existing emerging local plan, this has been going on since 21-22, as you will be aware, and that in late December 24, our new government issued an NPPF National Planning Policy Framework that has fundamental implications for plan making and planning decisions from the date of its publication. The general requirement was that many local authorities that had out-of-date local plans were required to start again on criteria which was not provided at the time and indeed has still not been clarified. This would have involved considerable expense for us if we have had to follow that format. Given the prudent policy of this administration, despite concerted opposition, we have pushed forward with our emerging local plan with as much speed as the system permitted. We are now therefore entitled to continue with our existing local plan and not start all over again. A proviso then emerged that we had to submit the Regulation 19 format to the Inspectorate following consultation for inspection by the 12th of March 25 to achieve that exemption. That consultation determined in December, having produced 660 responses. They were reviewed, and as no basic, unforeseen and significant issues were found to have arisen that would have required further consultation, the submission was made on time. However, as a consequence of being allowed this concession, there was also a statutory obligation under the Levelling Up and Regularisation, which one is it? Regulation Act, that we had to start as soon as possible a new and supplemental local plan in order to address the shortfall of our local housing need. The shortfall came as a bit of a surprise in the overnight our new government arbitrarily decided to impose a new methodology of calculating our local housing need, which effectively increased our requirements of new residential homes from 123 per annum to 266. The potentiality which would require a further 3,800 new homes over the period of the plan, and over and above the 1,200 which we still have to push forward with. A major consequence of this decreed local housing need is that we no longer have a demonstrable 5-year housing supply. So the tilted balance therefore now applies, and planning applications should now be granted unless adverse impacts would significantly and demonstrably outweigh the benefit. This will remain as our standard position until this emerging local plan is adopted, which is estimated in May 26. Council has already indicated its approval and compliance with the preparation of this new further plan. which was essentially inevitable should we proceed with utilising the exception of continuing with our existing plans. It does, however, present two further options. Firstly, commencing work as soon as possible, or secondly, delay it. The recommendation is the former because it meets the government's demands and the fact that reduces the risk, the fact is that it reduces the risk to the EPL examination should any perceived delay be evident. Further, it will provide the earliest safeguard for our future of our housing supply figures. If I move to the second recommendation, which is to approve the Rutland Local Development Scheme for 25-28, which is outlined specifically in terms of Annex 1. It is a statutory requirement to prepare and to maintain a local development scheme. This is basically to provide a timetable for a local plan or a local plan revision or any other local plan development. You will have read that it initially sets out the existing documents and policies that are extant at the commencement of the period. The original policies, the mineral core policies are of 2010, a Rutland core strategy of 2011, the site allocation policy of 2014. These will all remain until they are replaced by the emerging local plan. It then goes on to list the supplemental documents, which are listed down at point 1.4. These are supplemental planning documents which aid the system. Thirdly, it goes on to list the detailed further current development plan documents, such as the statement of community involvement, the community infrastructure levy, and the authority monitoring report. This is all very formulaic, but it's something we have to do. The fourth section is the forthcoming proposed documents, which of course is the emerging local plan. Paragraph 413 gives the key milestones of this, and the remaining ones are that we will have set regulation 24, which is the examination and the receipt of by the inspectorate and the receipt of the inspectorate report in 25, and set regulation 26 goes on to the final process for adoption. The last document will be the new local plan itself. The details of the approximate time schedules are referred to until the end of 25, which will include a period of 4 months public notice of intention to start the process. It also includes proposals for scoping and the formal timetable. This will go on to probably the end of this year. Months 1 to 23, which will essentially 26 and the whole of 26 and 27, will be involved with the planning, the visioning and development of strategies. This period will also include the first public consultation. Months 24 to 30, examination of the plan will lead to its final adoption, and this is estimated to be by June the 28th. To June 28, not June 28th, I apologise. This is a good graphic plan, which you will see shows the estimated time schedules for both the emerging local plan and the new plan. In respect of the oversight of the local development scheme, the document confirms the continued reliance on the cross-party local plan working group in respect of finding evidence, looking at evidence, drafting policy and making recommendations to Cabinet. The authority monitoring report will also deal with the situation should the work proceed slower or indeed quicker than programmed. In respect of the perceived risks, it details and explains all the usual suspects: resources, staff, turnover, changes in the planning system and the legal challenges. Don't worry, I'm coming also to an end. The third recommendation concerns the approval of the Memorandum of Understanding between the Council and the landowners of Woolfox site. It should be noted that this document does not create or legal binding obligations, and neither is it any form of contract for services. It creates basically an informal structure for dialogue as to the proposals for development. Again, the council has two options. The document is approved and agreed by the parties. It therefore provides the council with an active role in assessing the potential capacity, the constraints and the deliverability of the site as a whole on terms that we approve. Or the council limits its role to the conventional process of reviewing the plan making and making decisions. We appreciate this project will be towards the end of our new plan, but as there are so many planning complexities and there is an overarching timeframe limitations, we need to start preparation of the master plan for both Woolfox and for the St George's Barracks site. We're also conscious that to avoid over-reliance on development at the edges of towns and villages, we need to prepare this plan as soon as possible. Indeed, to have a holistic approach and planning criteria to adopt it in those proposals, which will be the centre of the forthcoming proposals that we would like to approve. Recognising these criteria in respect of Woolfox clearly indicates the first option being preferred, and the first step is the implementation of the proposed Memorandum of Understanding. The recommendation is sought for its approval. As an aside, in respect of the St George's Barracks site, there are suitable arrangements already in place with the MOD to bring forward this site, and our planners are currently exploring with the MOD how this can be further expedited. I ask, therefore, that these three recommendations are approved by Cabinet.
Thank you, Councillor Brown. Does anybody wish to say anything? Councillor Johnson.
Yeah, thank you, Chair. I just really wanted to comment on the route that we've taken in this case, because I know this will be the subject of some conversations at parish councils and outside parish councils, and I think it's important to say that at every stage in the emerging local plan and in adopting this paper and this policy, what we've tried to do is protect the county as far as possible with planning policies which allow us to make sure that development occurs in the places that we believe we need it, rather than where it is just proposed. And so I think it's important just to say that we believe that, given that the new MPF wasn't published until the 12th of December last year, and we've had to do a lot of work since understanding the implications of it, because it's a complex policy, that this proposal represents the optimum route to make sure that we protect the county from unwanted development, and that we continue with developing local plans and policies that are relevant at this point in time.
Thank you. Anyone else? In which case, the recommendations are that Cabinet notes the updated position regarding the emerging local plan and commits to the preparation of a new local plan under the revised plan-making system provided for under the Levelling Up and Regeneration Act 2023 as soon as the relevant provisions are brought into force in 2025. Approves an update to the local development scheme as set out in Appendix 1, and approves the Woolfox Memorandum of Understanding as set out in Appendix 2. That's been proposed and seconded. All those in favour?
That's unanimous, Chair.
Thank you very much, ladies and gentlemen. I haven't been notified of any items of urgent business. The next meeting is the 13th of May 2025, and I close this meeting at, I'm not quite sure, is it 5:02? 4:45, at 10:45 a.m. Thank you.